And sir, I've got you as Jim Perdue, Self and Texas Trial Lawyers Association against the bill. Is that correct?
Yes, Chairman Frank, Vice Chairman Rose, members. My name is Jim Perdue. I'm a past president of the Texas Trial Lawyers Association and here against the bill.
But you are testifying, you're past president, but you are testifying on their behalf.
I'm testifying on behalf of the association, which is
I just want to make sure.
Association. They gave me the proxy, I guess, for this
no, that's great.
Late in the day.
Yeah, absolutely.
Let me address 4 issues that we have with this particular bill in the current language as it exists. Representative Ramos, you've already identified one of them. First is in Section 170A of the bill. The bill is designed to take what is current law, that is that SSCCs achieve the benefits of charitable immunity, which is the Chapter 84, which the chairman referenced. That's where you find the $500,000 per person, $1 million aggregate limits on liability. That already is the law as applies to SSCC. The bill then creates or attempts to create, there's some language questions which perhaps could be worked out obviously with the stated intent. But you'll see in the caption, or other entity contracted to provide child welfare services. Now, the identical language from the current law, which provides charitable immunity to SSCCs, remains until basically an amendment which expands the scope of that charitable immunity to SSC, the entities that are contracting with a Department of Family Services. Achieve this immunity today, achieve this cap today. This bill, according to that language and the expansion of the immunity, takes it now into the individual persons who are employed by other entities, not SSCCs, but other entities of any nature that contract with family services.
Okay.
So it expands the universe of people who achieve charitable immunity from just SSCCs, and captures not only those entities, but also down to the level of the individual employees of those entities. So any contractor to DFPS now gets the benefit of the charitable immunity cap. Then in Section C of the first section of the bill is where Representative Ramos, those caps apply indeed for negligence in the supervision or treatment of a child who's in custody of such an individual or other entity that's not an SEC. But it then changes the standard of proof. And that is not even the current law as applies to SSCCs when it comes to the immunity and the caps that they receive. So you have an expansion of the universe who receive the cap, and then you elevate the standard of proof for anyone who is attempting to bring a claim for negligence from what is civil law, preponderance of the evidence standard of proof in all civil cases, to a clear and convincing evidence standard. So you expand the universe and then you limit the ability to even prove a claim by changing the burden of proof in Section C. That language regarding
you're to your first 2, but I'm gonna you're out of time, which is fine because I'm gonna ask you some questions.
Well,
you're really doing you're doing you're doing. And honestly, you're doing. I was just saying. I don't mean to ignore that,
it's been an extremely long day for everybody.
It has, but I think we're bringing up some. I mean, you really are bringing up some very good points because I think so. Currently, the SSCC, who has no reject, they are in charge of that region. I argue they really are a quasi-government entity. They are, all the kids are their responsibility. 100% of the revenues come from us. It's like, and so they have the charitable immunity, right?
Yes, Jim.
Does anybody else in the sphere of any of their subcontractors currently have? Most of them are nonprofits. Most of those have charitable immunity. Nobody else has charitable immunity.
Not within the setup within the family code for these types of entities. Now, charitable immunity is relatively broad in Chapter 84 of the Civil Practice and Remedies Code. There's a long list of nonprofit entities that qualify, very specific instances of which they do, and they get the 501 million cap in those instances. But these entities are not in that list.
Okay.
So the change in the law is to broaden the universe, but perhaps more problematically, if the idea is a cap could apply to these entities, the standard of proof for the causes of action is elevated. And then again, in Section D, when it comes to negligent hiring and training, and it's really these cases tend to function on review of the applicant, the review, the hiring file. That then is bracketed down to, again, clear and convincing evidence, but of only two things that can be brought to establish negligent hiring. So it limits your ability to establish the negligent hiring claim only to the entity's contract with the department or the laws and rules under the Human Resources Code, as opposed to the general duties that apply to any entity in the hiring process. And lastly, just briefly, Your Honor, Mr. Chairman.
No one's ever called me honorable. It really is late.
I defer to the doctor on all things medical, and I get in the courtroom. I apologize, Mr. Chairman. But then in E, and I'm not sure this is intended, but it was Representative Ramos pointed it out. Then the last section of it says that the idea of vicarious liability, that is that these entities employ these individuals now enjoy this immunity. And this, I think, inverts probably exactly, Mr. Chairman, what you were raising. The worst actors, that is somebody who is guilty of a crime or an intentional criminal act of violence against one of these children, if that is the underlying claim for the employee, there can be no vicarious liability, according to the language of this statute, for the entity that employed them.
Right.
So that is the concerns that we have with the bill. And with that, I'll take any questions.
Okay. And no, I appreciate it. And I'm trying to figure out a kind of an intelligent way. I do think I don't know that that's what was meant in the bill. We do have drafting errors and that kind of stuff sometimes that I do think somehow we have to address this. I don't know if you're probably not in a position to speak on behalf of what seems to make sense, because I think when we have a government service, and in this case we have something that the government has said we need to take care of these kids, and many of them are high risk and are creating, and we want to make sure people can take care of them, and we want to make sure the bad actors are punished. But I always think it's interesting because if it's handled by a school or anything state related, it seems like we can do nothing. There's sovereign immunity, and there's like nothing. We go after the individual and nothing happens to the organization. As soon as we have a private entity handling it, it's like, let's go. And then all of a sudden we can't have a private entity handling it, or we're spending more money on insurance than we are on actually taking care of the kid. I didn't know if I'm kind of rambling a little bit, but if there's a middle ground, or if you actually had the charitable immunity to most of these organizations, there's a dollar amount out there, 500 and $1 million. It seems like a fair chunk of money, but you can insure for that. I don't know if you have a thought on that from an organizational standpoint, or
I'm going to desperately try to avoid getting into Family Protective Services policy questions. Right. But I will say that the body made a decision to grant that immunity to SSCS, which is exactly what you said. Truly are standing almost in the shoes of the government and now achieve that. What this bill does, and I think that there may be some issues. The problem with insurance rates is it's always anecdotal until you get into the real data. But you're taking now private entities, which, again, as far as drafting issues, are supposed to be nonprofits, but may be for-profit because of the breadth of the bill, and giving them the benefit of these caps, but then also an elevated standard of proof, which they wouldn't have. And quite frankly, that wouldn't even be true in a Texas Tort Claims Act situation. Right. So,
okay. Thank you very much. Members, yes, Representative Ramos.
Thank you. And thank you for pointing out the other entity contracted to provide child welfare services and related personnel, because that is so just wide in terms of who would be exempt from this. But in terms of, or what you could perceive based on how the bill is written, what would be an example of the clear and convincing evidence? How would one obtain clear and convincing evidence, let's say in the what really concerns me, a lot of pieces, but a claim based on an employee or volunteer's conduct that is intentional or done with conscious indifference or reckless disregard for the safety of others. So I'm an entity and I know that I'm hiring a child molester or whatever, but you as the claimant have to prove clear and convincing evidence. How does that work?
So as a civil litigator, everybody's familiar essentially with the burden of proof in criminal cases beyond a reasonable doubt. And there's a body of case law that establishes that in criminal context. In all civil cases, the burden of proof is by preponderance of the evidence. That is what is more likely true than not true. That applies to negligence cases, even negligence cases against a school board or a state entity.
More likely true than not true.
The Texas Supreme Court has defined clear and convincing evidence as something just less than beyond a reasonable doubt in a civil context. So if you have, for example, just a horrific case of abuse, the case out of Dallas or Fort Worth where a child died from a brain hemorrhage, you have that underlying intentional act. Now, that's clearly been done with intent in a bad act, but the negligent hiring retention of that individual is subject to what did you review? What did you get in a background check? What did you know? When did you know it? How long have you known it? And there is almost no instance where the concept of negligent retention or hiring, where I can verbalize for you what exactly the evidence would be of clear and convincing evidence under the Texas Supreme Court evidentiary standard.
You have to get in the mind of the individual.
There is actually a subjective element to clear and convincing, according to the Texas Supreme Court and the malice standards. So the idea of caps is one thing. The idea of changing the burdens and the nature of the cause of action is a very different one.
Thank you.
Thank you very much for your testimony. It was very good. Members, any questions? Thank you.
Thank you, Mr. Chairman.
Chair calls Michael